A very warm welcome to the third lesson of our 50-part series on the law of evidence. I will first talk about something that you perhaps may not have noticed. I have always been using the phrase the law of evidence rather than the Indian Evidence Act. What is the difference between the two? We will learn this. Also, we will look at three fundamental canons, the three fundamental principles for the law of evidence in this video. Alright. So in reference to the law in India relating to how evidences are to be dealt with, what is the difference between referring to that as, on the one hand, the law of evidence and on the other as the Indian Evidence Act? What is the difference? You see, we are aware that Indian Evidence Act is an act of 1872, right? And it is the law that governs the law of evidence in India. So why am I making a distinction between these two terms? Let me ask you another question. Perhaps since you've studied criminal law a little more, what is the difference between saying law of crimes on the one hand and Indian Penal Code on the other? Again, you're aware of this Indian Penal Code. It's an act of 1860, right? What is the difference between saying law of crimes and Indian Penal Code? You see, when I say law of crimes or the law of crime, depending on how you want to term it, this refers to both the substantive law of crime as well as the procedural law of crime, right? Within the substantive laws of crime, you have several provisions. You have the IPC, right? Also, let us say you have the NDPS Act, for example. You see, that is also an offense related statute, right? It tells you some offenses, it tells you as to what a crime is or what an offense is. So you see the IPC, and then on the other hand, of course, when I talk about procedure, you might have the CRPC and several other laws that talk about procedure relating to crime and so on. What I mean to say is that the IPC constitutes a very small part of the larger umbrella of a law of crime, which means that Indian Penal Code, this one, Indian Penal Code is a subset of the entire laws relating to crime. So the law of crime refers to a much wider and a much larger bucket, and Indian Penal Code is just one statute. Of course, it's a very important statute, perhaps the most important statute relating to the law of crimes in India, and that's why sometimes people might use that interchangeably. But that doesn't change the fact that the Indian Penal Code refers to just one statute, whereas the law of crimes is a much larger term because you can find the law of crime even beyond the IPC. Having given you this hint, I think you perhaps would know as to what the difference between law of evidence and Indian Evidence Act is. Let's take this discussion a little further ahead. Okay, when I say that there's a difference between law of evidence and Indian Evidence Act, it means that your law of evidence is the larger circle. So you have laws relating to evidence in the larger circle, and inside that you have the Indian Evidence Act, which also gives you some principles relating to laws of evidence, which means that you ideally should be finding the laws of evidence elsewhere, right? It's important for you to know that the Indian Evidence Act is what is known as a consolidating act. Let me tell you what that means. You see, consolidation, this word itself is kind of self-explanatory. So consolidation means that, let us say, at the time when this law was enacted, 1872, local courts had their own laws relating to procedure and evidence, right? So what was decided when this act was passed was that there should be a consolidation of existing laws, and then that is codified. Okay, so there's a codification, and that statute consolidates all of those laws which were otherwise very fragmented, right? You might have heard of this phrase, consolidation of land holdings. What that means is, let us say there are many pieces of land that are fragmented, lying here and there, scattered. You consolidate them, right? You're also told to consolidate your study material before the exam. So you understand what consolidation means. It means that you pick things from bits and pieces from here and there and you consolidate them. So you understood the first thing about the Indian Evidence Act. But another important point that you should remember about the nature of the Indian Evidence Act is that it is not the exhaustive law on evidence, which means, like we just studied earlier, that the Indian Evidence Act gives you the law of evidence, of course, but it is not exhaustive. You also learn the law of evidence from other places, which means that if I am teaching you the law of evidence, I would inevitably have to also talk about other statutes, about judgments, because the law of evidence is bigger than just the Indian Evidence Act. So what we'll do now is that we'll have a look at some places beyond the Indian Evidence Act where you can find some laws relating to evidence. Don't worry, you're not required to learn these, you're not required to memorize these. It is just to illustrate the fact that you can find the law of evidence beyond the Indian Evidence Act. Let me first give you some examples from the CRPC. For example, you have section 162 of the CRPC, which relates to statements that have been made to the police, and it talks about how they aren't admissible as evidence. So you find a principle of evidence in 162 of CRPC. If you want, you can go ahead and look at these provisions, or you can leave that for later. Similarly, sections 273 and 279 of the CRPC talk about the fact that evidence in 273 requires to be taken in the presence of the accused. 279 on the other talks about situations in which it can be done in the absence of the accused. These also clearly are principles relating to evidence. Likewise, 277 of the CRPC talks of the language in which evidence is to be taken. 280, and this is a very brilliant provision relating to the appreciation of evidence in a way, and it talks about the fact that the court can look at the demeanor of the witness. So you look at how the witness is, and on the basis of that you can have some remarks that will influence the decision. So you can see that there are some provisions, I mean there are many more, I just want to illustrate with a few, many provisions relating to evidence in the CRPC, right? Just to illustrate to you that the Indian Evidence Act is not the exhaustive law on evidence. You have the law of evidence elsewhere too. Now we'll look at some examples from the CPC. I'll briefly take you through a couple of provisions of the CPC. In case you're curious enough, you can go and have a look. So sections 137 and 138, for example, deal with the language. So 137 talks of the fact that the evidence should be recorded in the local language. 138 talks of when it can be in English. Another example would be Order 7, Rule 14. Order 7, as you know, deals with the plaint, and Rule 14 talks about the fact that the plaintiff should bring the documents that he relies upon. So you see, bringing the documents again relates to evidence. It's a procedure relating to evidence. Likewise, under Order 13, Rule 3, you can see that there can be a rejection of irrelevant or inadmissible evidence. Again, a rule relating to evidence. And in fact, the whole of Order 18 deals with the examination of witnesses, right? So you can see that there's a lot of evidence law that is beyond the Indian Evidence Act. Summarizing this entire point, I can say like this, that perhaps the law of evidence is the Indian Evidence Act plus other things. Of course, the Indian Evidence Act is the most important, and that is why we will be studying this in the most detail. But do not forget that the law of evidence lies even beyond the Indian Evidence Act. This brings us to the second part of our lesson, where we discuss the three most fundamental canons of the law of evidence. I hope you now appreciate the distinction. I am not saying principles of the law of the Indian Evidence Act. These are principles of the law of evidence in general, right? The first amongst these is that evidence must be confined to matters in issue. What that basically means is, let us not talk about irrelevant and unconnected things. We should only talk about things which are connected to the matter that has been brought before the court. I will talk about these in detail in a bit, but for the time being, what this rule basically means is that let us not talk about remote, distant and unconnected things. Let us not talk about irrelevant things. The next thing is that hearsay evidence must not be admitted. Now, what is hearsay? Hearsay means that it is not something that you have sensed with your own sense organs. It is something that has been told to you by someone else. It's kind of like the Chinese whisper. Let us say this person has seen something. Okay, he's seen a certain occurrence, a certain murder or whatever. And now he tells this to you, and now you tell this to someone else. And now this person decides to go as the witness before the court. Okay, so what the court says is that you're talking about a certain incident. Have you seen it? Have you heard it? Did you feel it? If the answer is yes, well, it is direct evidence. If it is not, then it is hearsay. So what the court says is that if you're talking about something, I don't want to hear it from you. I do not want to hear it from you either. We want it coming from the horse's mouth. Okay. So the other rule is that hearsay evidence is not admitted. Going ahead. The third rule is that the best evidence should be given in all cases. Now, what is the meaning of best evidence? You see, for any given fact, there are various kinds of evidences that can be produced. You see, let us say there was a certain occurrence that happened, say here. Okay, let us say there was a fight between two people here. Okay, now let us say there's one person standing and watching from here, and obviously when people are fighting, then there's a large crowd. Okay, so you have a large crowd of people. There is one person standing here. Okay, and beyond this crowd here, there's somebody standing here. Now if I ask you a question, who is better placed to give you evidence, this person or this person? You see, a person who's standing so far back is perhaps not the best source of what has actually happened. So what we try to do is that in all cases, if we have two witnesses, let us say if it is possible for us to get this person as a witness as well as this person as a witness, you try to get the better evidence in every possible case, which basically means that in all cases, whenever we are trying to prove a fact, we try to get the best possible evidence. So these three principles are the fundamental canons on which the law of evidence is premised. We'll look at these one by one now, starting with the first one: evidence must be confined to matters in issue. You see, evidence is given to prove facts, right? And facts can be either connected or unconnected. For example, let us say we are talking about the case of the murder of somebody, right? Now, what are some possibly connected facts? Where was he at the time of the murder? Good question. Does he have any weapons with him? Good question. But let us say we look at some other facts which perhaps may not be so connected. What is the color of his first guitar? Well, doesn't matter. Does he keep his head on facing west or does he sleep facing east? Is this important? Perhaps not. So what we decide is that we do not give evidence for unconnected facts. And when we talk about unconnected or connected, the better terminology that we could use is that of something being relevant or irrelevant, right? So this first principle is basically a rule relating to relevancy, which means that we only admit evidence, we only give evidence for matters that are in issue, which means that those are disputed and they are connected to the matter at hand. So this first principle is sometimes also referred to as the rule relating to materiality. What this basically means is that we confine ourselves to evidence relating to the material facts only. Right? So I hope we've understood the first principle. Let's go ahead and have a look at the second. The second principle says that the best evidence must be given in all cases. Now, what do we mean by the best evidence? The best evidence means that the evidence requires to be what we might believe as the most reliable evidence. Sometimes we also use a few adjectives like these. What is the clinching evidence? What is perhaps the most coherent evidence? What is the most trustworthy evidence? And so on. So basically we are looking at the quality of the evidence, and let us say we have several pieces of evidence. Then we need to give the court and we need to present the court with the best possible evidence that is available, right? And it's important for you to remember that this quality of evidence is kind of spoken of in terms of weight, right? We understand that evidence is weighed and not counted, so we understand the quality of evidence in terms of weight. It's just how we see and we conceptualize evidence, that the quality of evidence is seen through its probative value, right? It's the same thing, the probative value. That's what we mean by, so when something has high probative value, it means it has high quality, and it is seen as something which has a lot of weight. Finally, we briefly discussed this rule relating to hearsay evidence. Well, for the detailed video on what direct evidence and hearsay evidence is, you can watch this video by clicking the I button relating to section 60 of the Indian Evidence Act, but I'll briefly discuss the concept with you here. You see, let us say there's an incident. The incident is that there is say a person who was murdered in a certain fight. So he's lying in a pool of blood, and he was fighting. Let's say he was killed by this person. This person has in his hand a bloody knife. Now this was seen by this person here, right? So this person saw it. Now what this person does is that he goes and tells his friend, okay, that he's seen something, and now this person goes to the court and deposes before the judge, that he says that okay, A killed B. Now what the court concerns itself with is that, sir, before I admit what you are saying, I first need to know whether you actually saw what you're speaking of. In case it has been sensed by someone else, which means that someone else's sense organs were used, the eyes were someone else's, but the mouth is someone else's, you see. So in that case, it is hearsay, right? So the rule of not admitting hearsay evidence is that a person who has sensed it should come to the court and depose before the court himself. You might recollect that we used to play this game of the Chinese whisper, right? So you have this entire circle that is made, and one person tells someone something, and so on, and then finally when it gets back to this person, he hears a very distorted version of what he started off with. So this rule has basically been embodied in the Act as well as in the whole law of evidence to prevent this mischief, to prevent such an occurrence whereby there's a distortion of facts once it gets carried from one person to another. So this is a rule again relating to the authenticity of evidence. To conclude today's session, what we learned was that there are three fundamental principles, three basic pillars that govern the law of evidence, and the law of evidence is not just the Indian Evidence Act, but more. I hope this session was of use to you. Thank you for your patience. Good day.